Minutes. We'll be back at 11 a.m. Thank you. Well, welcome back. So we're going to resume our program for the rest of the morning. Just a reminder, in about half an hour, we'll be having our Q&A session. So we just ask people in attendance, if you have questions, sorry, just lose my voice for a second, please write them down on the sheets and we will collect them. And for those of you who are at home, there's the Q&A button at the bottom of the Zoom screen that you can click on to pose your questions. Our next speaker is Natalie Caballero. She's our new associate, and she's certainly hit the ground running this year. So we're looking forward to her presentation. She'll be speaking about employment policies and what you gotta have and what you should have, and some tips on how to make your policies work for you as an organization.
Goodness, I am short. Okay. Hello, everybody. Thank you so much for coming out today and trekking it through the very cold weather that we have today. So as Landon just indicated, I recently joined the firm. And since I joined, a growing part of my practice has been reviewing employers' policy manuals to determine whether or not they're in compliance with Ontario legislation. So that's pretty much what today's presentation is going to be about. It's going to be about ensuring that you know what policies you must have, and as well as discussing the ones that you don't have to have, but we still think that you should. So let's start this. Okay, so just to preface my presentation, it's going to be extremely detailed, my slides. However, I'm just going to be going over the key points that I want to present to you just for the sake of time. So here's just a little overview that I already discussed. And let's get into it. So the first topic that we're going to be talking about today are mandatory policies. So I've divided the mandatory policies into 4 subsections, which are divided based on which piece of legislation mandates them. So the first piece of legislation is the Occupational Health and Safety Act. And this is the perfect first one to talk about because Ryan just spoke about OSHA in great detail. So OSHA requires 3 mandatory policies to be in place. So there is a workplace occupational health and safety policy, a workplace harassment policy, and a workplace violence policy. So all of these policies are required for every single worker across Ontario in every workplace. However, only workplaces that have 6 or more workers employed regularly are actually required to have this policy written. And in addition to this, so it's a bit confusing because OSHA doesn't actually define what regularly employed means. So we have to turn to the Ministry of Labor and the courts to see how they have defined it. So they have defined it as employment that exceeds 3 months, as well as independent contractors who habitually or customarily perform work for an employer. So it's important that you're factoring in these definitions when determining whether or not you meet the quota to have a written policy. A lot of employers will say to part-timers, do they count as 0.5 of a person? No, if they're a full person, you count them. If you have 6, you have 6. Okay. So as you can see right here, the first policy we're going to talk about is the Occupational Health and Safety Policy and Program. And it is mandated, and there's 2 separate elements. As you could tell from the title, there's a policy and a program. And the program is pretty much meant to make the policy become actionable. However, I'm going to be talking about specifically the policy today, but of course my slides have elements of all of them for your own review. So the policy has to have several key components as listed on the slide, but the most important aspects, arguably, include laying out the roles and responsibilities of workers, employers, and supervisors. This is going to ensure that every party in the workplace knows what their roles and responsibilities are in relation to health and safety. Second, the policy has to include a process for hazard identification as well as regulation. And this makes sense because once a hazard is identified, we want to make sure that we're remedying it and making sure that accidents don't happen. So on the slide here, I have a hierarchy of different ways that you can manage risks. Right at the top, we have elimination. It's not always possible. So maybe, providing PPE equipment or some of the other options that I have listed out. So the policy should also include procedures on how all parties can report hazards and ensure that whatever procedure that you are choosing, make sure that it has an option of to be anonymous, right? Because a lot of employers might fear that they're going to face reprisal when they are reporting a hazard in the workplace. So we want to make sure that they feel comfortable coming forward with any hazards that they might find. Okay, so the second policy that's required under OSHA is a workplace harassment policy. We've already heard from Robert about the harassment policy in Quebec, and it is very, very similar to the one that we have here. So employers typically merge their harassment policy and their violence policy into one because the requirements are pretty much identical, of course, other than the definition of what violence is versus harassment. But for the purposes of time, I'm only going to be going over harassment today, but the violence policy is in your slide deck. So the first element of the policy, it has to include a definition of harassment, which is laid out in OSHA. So just for us to know what it is right now, it is engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome. And this includes sexual harassment as well. So many employers also choose to include the definition of harassment in relation to the Human Rights Code. It's kind of a one-stop shop. You can have both of them included in the same policy. Definitely doesn't hurt. So something that I also like to add when I'm reviewing employers' policies is a definition of what harassment is not, right? A lot of employees think that constructive feedback from an employer, for instance, is harassment. Constructive feedback may not always be great to hear. It might sting, but it's not harassment. So indicating what it's not, it can serve as clarification for employees. Second, the policy has to include reporting mechanisms and investigative procedures. So, of course, employers have a duty under OSHA to investigate all complaints of harassment. So understanding when this duty is triggered is very, very important. So I think that the best practice would be to always take any complaint seriously that comes before you, investigate it, and have a paper trail of how you're investigating it. Even if it doesn't seem very serious at first, you want to make sure that you're doing your due diligence as an employer. Okay, so this is important. Before I move on to, well, I already did. Before I move on to the next slide, I just want to touch on the consequences that could occur if you do not have these OSHA policies. So theoretically, the consequences can range from severe fines and it can go all the way up to prosecution. But just a cursory look at the case law shows that this is not actually happening. So you don't have to lose sleep tonight if you realize you didn't have one of these OSHA policies. You're probably not going to get prosecuted for it. But there are still serious consequences that you could face from the court, for instance. For if you were to fire someone for just cause for harassment, the courts have made it very clear that if you do not have a harassment policy in place, this could constitute wrongful termination. Because the employer has the employee should have the ability to see what harassment is and what the consequences would be for engaging in it. So overall, it's just better to ensure that you have your policies in order to avoid any type of consequences for not having them. Okay, so now we're moving on to workplace discrimination policy. So I put this into the mandatory section, but it's not actually mandated by any piece of legislation in Ontario. So of course, every employer in Ontario does have a duty to accommodate employees' needs if they arise under a protected ground under the code, up to the point of undue hardship. However, the Human Rights Code and no other piece of legislation requires you to have a discrimination policy. However, we would still advise that you still have one, and this is because the Human Rights Tribunal expects you to. So if you're ever defending your organization against a human rights complaint at the tribunal, in your response, you're actually going to be asked whether or not you have a policy related to discrimination. So there's a clear expectation from the tribunal that you have one in place. And if the tribunal is awarding damages against your organization, they're going to take this into consideration. So sure, it's not legally mandated, but there's severe consequences for not having one. Okay, so now we're going to move into accessibility and accommodation. And the policy I'm going to discuss here is mandated under the Accessibility for Ontarians with Disabilities Act. So this is the policy. It's called the Accessibility and Accommodations Policy and Plan. And there's two components to this policy. There's accessibility and accommodation. They're two separate but very related topics. So your obligations in relation to this policy are going to depend on how many employees you have. So if you have less than 50 employees, you're kind of off the hook. You're supposed to have an accessibility policy, but theoretically it could exist in your mind. You don't actually have to have it written. You don't have to provide training. We would still recommend that you do that to make sure that your workplace is accessible. However, the real obligations arise if you have more than 50 employees. So if that is the case, you have to have a written policy on accessibility. So I've indicated all of the elements of what that would include, but I'm just going to talk about a few of them. So the first is that the policy will indicate the company's commitment to ensuring accessibility. And the second element, which is quite interesting, is that you're going to have a multi-year accessibility plan. So this is where you're going to indicate the company's long-term goals to ensure accessibility. So for instance, this might include retrofitting an elevator or even installing elevators in a building that there are none. So this allows you to plan for that type of expenditure and process. And you're going to keep on updating that every 5 years to make sure that your company is continually committing to new accessibility goals. So finally, the second part of this is about accommodation, right? So everybody, as I indicated, has an obligation to accommodate in line with the Human Rights Code. However, the nature of how these accommodations are provided is also going to depend on how many employees you have. So if you have less than 50 employees, you have to accommodate your employees where possible and allowable. But you don't have to have a written accommodation policy or plan. You're able to do this on a more informal basis. However, if you have more than 50 employees, you are going to have that written accommodation plan that's going to outline the nature of the accommodations, as well as how often the employee and the employer are going to meet together to discuss how those accommodations are working and whether or not they need to be changed going forward. Okay, so the final piece of this accommodation policy, it's not necessarily a policy, but it's something I wanted to highlight. And it just has to do with accessible recruitment processes. So this applies to every employer across Ontario. You would have to inform all potential job applicants that there is the ability to get accommodations during the interview process, during the recruitment process, and all of that. So you want to make sure that they're aware of this, and you'll typically see this on Indeed. When you see a job posting, there'll be a little paragraph that says accommodations are available upon request. So that's something that's mandated for all employers across Ontario. Okay, so now we're going to move on to the Employment Standards Act, which can be a bit of a headache sometimes. It's very convoluted and there's a lot of interpretation that's needed. But luckily, there was only 2 policies that are required under the ESA, and they were introduced in 2021 and 2022, respectively. So both of these policies only apply if you have 25 employees or more as of January 1st of a given year. If you meet this quota, you are required to have both of these policies in writing by March 1st of that same year. And then within 30 days of March 1st, you would have to provide it to the employees or upon 30 days of hiring them. So here is the first one, the disconnecting from work policy. So the name is pretty straightforward, right? It's a policy on an employee's ability to disconnect or their non-ability to disconnect from work. So a lot of employers were very concerned when this policy was introduced because they thought that it would limit their ability to contact employees after their hours. But that's not the case. That's not what the policy is or what it requires from you. So I indicated a few elements that are recommended. However, the ESA doesn't actually specify what needs to be in this policy. So theoretically, a policy that says you are never allowed to disconnect from work ever is still compliant with this policy. However, if you do choose to implement that type of policy that says you're never allowed to disconnect from work, make sure that you're still complying with your other ESA obligations, such as paying for overtime for hours worked. Okay. Next ESA policy is the electronic monitoring policy. So this was introduced in 2022. And pretty much it is what it says. It requires you not to necessarily stop monitoring your employees. It's just about making it transparent about how you're monitoring them, when you're monitoring them, and why. So for instance, a lot of employers will track internet usage on any technology that their workers use, like on company laptops, right? And if we catch Susan, watching Netflix during work hours, that's what the purpose is. But it's not that we cannot no longer do it. We just need to tell them why, that we are doing it and what methods we're using. And also to note, this obligation, it's not retroactive. So if you introduce it, like I said, on March 1st, if you were engaging in internet tracking yesterday, you wouldn't have to disclose those methods before. It's only forward looking. Okay, so now we're going to move on to the recommended and optional policies. So none of these are required by any piece of legislation. So here's a list of a few optional policies that we would recommend you having. This is not at all inclusive. There's an endless amount of policies that your company can introduce, dependent on what area you're working in. But just as an example of one that we commonly see, and it's definitely increasing, is a remote work policy. So after COVID clearly made a lot of people have to work remotely, and it seems to be here to stay. And that's great, but there are a host of new questions that we have to consider, right? Is there a mandatory amount of hours or days that the worker has to be in office? How is the employer going to monitor productivity going forward if they're not able to see employees? So essentially having a remote work or hybrid work policy, it allows you to set expectations so that both parties know what's expected of them. Okay, so with that in mind, right, if you're going to implement a policy that is optional or even mandatory, there's a lot of drafting considerations that you have to discuss and think about. So the first question that you want to ask is whether or not you want this policy to have contractual force, right? And it's like Jeremy was talking about, those pillars of a contract. We have offer, acceptance, and consideration. We have to think about that. So what we typically do is that we will put an all-inclusive clause in an employment contract that indicates that the employee agrees to abide by all of the employer's policies, right? So this, since it's already implemented into the contract, we have all of those pillars already fully met. However, it still leaves the employer a bit of wiggle room to be able to amend its policies without facing a constructive dismissal claim. So second thing we want to consider, if you're going to introduce a policy, you have to make sure that you're going to be able to follow them, especially in the case of a progressive discipline policy. the courts have been very, very clear that if you have a policy, employees are allowed to expect that it's going to be followed and vice versa. So Jeff's definitely going to be talking about that a bit more. And I have a case on the screen here. If I could put my glasses on, because I am. There we go. So it's the case of Johnson versus Swiss LA on Swiss LA franchise store. And pretty much the court indicated that where the employer establishes a scheme for progressive discipline, there is an expectation by the employee that the scheme will be followed. So if you're going to have a policy, make sure that you're following it. And by that same token, since you're expected to follow your policies, make sure that when you're drafting them, that's something that you can realistically do. Like if you have a 29-part investigation scheme that you cannot follow, it's almost better off to not have one. So make sure that you're making it allowable and make sure that you're giving yourself the discretion to alternate how you're going to investigate, for instance, depending on the circumstances. So instead of saying we have this 29-part scheme, you could say something like the employer agrees to conduct a reasonable investigation into the accident. So that gives yourself a lot more wiggle room and discretion to alternate how you're approaching these issues. Okay, so the final part of my presentation, we're going to kind of switch over to unionized environments for any employers here who are unionized. So fun fact, prior to working at Stringer, I was working at a union. And during my time there, one of the issues that I would frequently analyze is employers unilaterally implemented policies and determining how we can render them void. So the factors that we use to do this were called the KVP factors. So these factors came out of a 1963 case, which still lead the way till this day. So on the slide, I have all of the factors listed out, but for the purposes of the presentation, I'm going to point your attention to the first two. So the first one is the policy cannot be inconsistent with the collective agreement, and two, the policy cannot be unreasonable. So the union only has to prove that one of these two KVP factors has not been met in order for your policy to be rendered void. So these are the two most important factors, right? So cannot be inconsistent with the collective agreement. An example of this, for instance, if the collective agreement allows for flexible start times, and then the employer unilaterally implements a policy that requires a strict 9 to 5, that would go straight in the face of the collective agreement and it would likely be considered void. So with these factors in mind, I have a little case study that I want everyone to go through. So ABC municipality was facing ongoing public health concerns, and they implemented a mandatory COVID-19 testing policy for all the employees. The policy states, 1, testing requirements. You have to undergo weekly COVID-19 testing regardless of your vaccination status. And second, it set out consequences for noncompliance. So 1, it was either immediate unpaid suspension for two weeks. And if you continued to violate the policy, you would be terminated for continued noncompliance. So the policy was introduced without any consultation or agreement from the employees union, which represents a group of public sector workers. So the union, of course, filed a grievance indicating that the unilaterally imposed penalties were inconsistent with the collective agreement, and the municipality argued that it was necessary and reasonable exercise of management rights. So does anyone want to guess what the outcome was here? Well, that's the answer. I can't show you that. Any guesses? So that's a great, so she said, wasn't it mandated by public health? So the Labor Relations Board, or the arbitrator in this case, they actually divided the decision into two parts. So they found that the mandatory policy for vaccination was allowed because it was a factor of public health. But the second element of it, which required termination, it violated the collective agreement because this collective agreement, it actually had a just cause provision. So since you can only terminate for just cause, putting in an automatic termination goes against the collective agreement language. Okay, so that's pretty much it, but I just want to urge, I guess, any unionized workplaces that when you are determining or thinking about implementing a unilateral policy without talking to the union, go back to the slide and use these factors and try to think about whether or not it would pass this test. Okay, and that's it. Thank you, everyone.